Good afternoon. Now, I hope these slides work. I'm bound to say I'm not very adept with these, but the topic I want to talk about this afternoon is expert evidence in health and safety cases and environment cases. And may I say, before you tumble this at the end, that most of the concentration here will be on health and safety cases, with just a short excursion into environmental cases. The reason I wanted to talk about this topic is not, in fairness, because it's a particularly hot topic in terms of something which is looming large on the horizon in terms of legislation or anything of that sort, but because it's been a topic which has concerned us all who practice in this field for quite a long time. And it's a topic which I felt deserved some consideration, at least, to look at it in I hope, some kind of analytical fashion. The main purpose being that if you are on the end of an argument which says, for example, that the expert evidence that you wish to call in a given case is not admissible, then at least having heard some of the things I have to say this afternoon, you may be in a position to mount an argument to say why that is inappropriate and why health and safety expert evidence should, or rather defendants should be entitled to call health and safety expert evidence in effect, depending upon the quality of the expert, whenever they wish to do so. So I start off with a proposition which is, I think, self-evident, excuse me, which is that, as we all know, that health and safety experts are routinely called in health and safety cases, and that's both by the prosecution and by the defence. As I say, one of the reasons that I decided upon this topic for a talk is that certainly from my experience, and I think from others' experience as well, there is a perception in many quarters, and when I say in many quarters, what I mean in general terms is from certain judges, certain prosecuting solicitors, and indeed certain prosecuting counsel, that the court's approach towards the admission of expert health and safety opinion is too laissez-faire. And in support of that, if you want to have a look at the Law Commission publication on the admissibility of expert evidence, which was published a couple of years ago now, you can see that that was an opinion which they expressed. And what they found was that the expert evidence opinion was being admitted in criminal proceedings too readily with insufficient scrutiny. Now, the focus, in a sense, of what I want to say is to look at the two types of expert evidence that are ordinarily called in this type of case. The first one is what we might call the generalist. And so, as I've said there, sometimes it's suggested that health and safety experts should not be allowed to express opinions on certain general matters of health and safety management. And what I mean in those terms are matters such as competence checking, risk assessment, supervision, and monitoring. And I think one of the most important aspects, which in fairness is not written down there, but on reflection, one of the most important aspects of general health and safety management is the issue of control. Because, of course, control comes into so many of the cases that we do where the allegation is, for example, that one contractor ought to have exercised a higher degree of control over a subcontractor. And that is something that I would say is a matter of general health and safety management rather than something which is specific. So, as I say, the perception, if it exists, and certainly my feeling is that it does, and it's probably going to harden up if anything else, is that experts, the feeling is that experts should only be allowed to express an opinion on their specialised subject. Now, be that construction, be that traffic management, be that lifting equipment, or etc. And one of the other reasons I thought it was appropriate to deal with this topic now is that we all know that health and safety legislation is being used to prosecute an increasingly wide range of activity. So it's not just confined to what it used to be in the main confined to, for example, construction and that type of thing, that we get health and safety to prosecute more everyday social concerns. For example, drownings in lakes, the organisation of fairs, and this type of thing. So the point being is that the experts that deal in a specialism associated with that type of case, their expertise is very limited. You may, for example, I have a current ongoing case, which I know some people here are involved in, which involves horse and carriage driving. So as you might imagine, the expertise in horse and carriage driving in this country is very, very limited. And so therefore, the question is basically, should the limited expert be able to express an opinion on more broad topics, and should the generalist be able to express opinion on general matters? So going on over, the feeling that leads judges to exclude or to seek to exclude this type of evidence is that allowing experts to opine on general issues is something which trespasses on the jury's ground. And what judges are prone to say is that the jury, by reference to the applicable guidance, is able to make its own determination about factors, for example, such as control, about risk assessment, about competence, and about general matters of organisation. And as I've heard it said, and as I've seen it in some skeleton arguments, judges and some counsel are prone to say, in effect, this is not an expert case, i.e., the jury do not need to receive an expert opinion, and it should not be, and they should not, in fact, receive an expert opinion to deal with the issues which crop up in a particular case. And one of the reasons why I personally, and somebody who both prosecutes and defends, one of the reasons I think this is actually off-beam and not necessarily a fair approach is that if you think about it, all cases which are brought by the HSE are founded upon essentially an inspector's view as an expert, because of course an inspector has to be an expert, as it were, in health and safety legislation, that there has been a breach of duty. So somewhere implicit in the prosecution's approach towards a case is the assertion or the assumption that there has been a breach of duty. The way that we tend to do it, certainly if no expert is called as part of the prosecution case, is that the view of the inspector is put into the mouth of counsel. So, for example, prosecution counsel will simply stand up and say, so far as we are concerned on behalf of the prosecution, there has been a breach of duty there. And of course, being prosecution counsel and making the speech at the beginning of the case, in a sense, the jury may think that the opinion given by counsel is invested with some credibility. I think that the phrase is an ex cathedra pronouncement, something which has the guise of being formal, of being establishment, and invested with that type of effect. So my own view is that whenever there is a prosecution for health and safety, somewhere there will be an implicit assertion, almost always by the inspector, that health and safety has been breached, and that will be at the back of the case. So I ask the question, is that fair, is that logical? And I'll hopefully answer my own question at the end. And the rider to this is, should a defendant be entitled to call a generalist in each case where a breach of health and safety legislation is alleged? So effectively, should you always be entitled to call an expert to say, in my view as an expert, there has been no breach of duty. Whatever was done here was reasonably practicable, and it was in accordance with the recognised standards of good health and safety management. So to answer the question, what I've done is strip back, hopefully, to some of the underlying principles for expert evidence. And the first thing to note is the test for admissibility is a common law one. There is as yet no statutory test. And this is despite the Law Commission's suggestion a couple of years ago that there should be a statutory test. This was a paper which was published by the Law Commission a couple of years ago and upon which the government has yet to act. There's been no adoption of the paper. So the four criteria which we would ordinarily apply in relation to expert evidence are these. So the first is whether it assists the jury, and that's the one which I'm going to focus on. The second and third are less controversial. Does the expert have the relevant experience? Forgive me. The third is impartiality, which of course we'll all be aware of. And the fourth, which is a slightly more vague and misunderstood one, is evidential reliability or evidentiary reliability. Just a little sidetrack. When we talk about expert evidence, we should concentrate on what is properly to be described expert opinion. Because, of course, you may get an expert who comes along, for example, to describe how a structure collapses, how how a particular piece of machinery works. And of course that won't be expert evidence, that will simply be factual matters which will be outside the understanding of the jury, and there should be no controversy about that being admitted. A less obvious one, and possibly a more hybrid category, is, for example, whether it's customary in the construction trade, and I take this merely as an example, for a principal contractor to take a particular step to supervise a specialist subcontractor. Now, of course, there is a duty on PCs at least to monitor a subcontractor, and it may be that ultimately whether in fact the PC did that is going to be a matter for the jury to determine. It may affect the question of whether they did all that was reasonably practicable. But certainly in my view, it would be in certain circumstances appropriate to call an expert to say, whatever my opinion is about this issue, if you look at what happens on the ground in construction sites across the country, this is what happens vis-à-vis principal contractors and specialist subcontractors. Not a matter of opinion about what should happen, but it's my view about what in fact does happen. So there is that slightly hybrid category in relation to expert evidence. So just to go through this, and I hope fairly briefly, because it's a little bit dense and, if I may say, rather boring. The first criteria, assistance for the jury, is the one that's most likely to be cited as a reason for not allowing expert evidence to be called. And the main case on assistance is the case of Turner, which goes back to 1975. And if there is ever to be an argument that expert evidence is not admissible, it's very likely the prosecution will be relying to some extent on the case of Turner. Now, for what it was worth, Turner was a case which was a murder case involving provocation. Mr. Turner killed his girlfriend with a hammer and sought to adduce evidence from a psychiatrist that by nature he was a fairly placid person, and therefore, because of his nature, that it was more likely that he was provoked in the circumstances of the particular case. And of course, this was going back to 1975, so you may understand that I suppose the admission of psychiatric evidence of that type was probably a bit more controversial anyway. So anyway, what was said in that case and in the Court of Appeal is that expert evidence is admissible to furnish the court with information which is likely to be outside the experience and knowledge of a judge or jury, if on the proven facts the judge or jury can form their own conclusions without help, then the opinion of an expert is unnecessary. Now, it's an expression, it's part of a judgment which is very commonly trotted out, but it does bear a little bit of scrutiny, because if you take the second sentence, outside the experience and knowledge of a judge or jury, well, knowledge, it may be that a jury would not have knowledge of, for example, the dense health and safety guidance or regulations which accompany various aspects of our work, but they may have experience in general terms of health and safety matters. Going down, if on the proven facts a judge or jury can form their own conclusions without help, then the opinion of an expert is unnecessary. And it's this criterion of unnecessary which is actually pretty vague. Being that the test is a common law test and there is no definitive statutory test, it seems to me that expert evidence in a health and safety case is liable in certain circumstances to be excluded by a given judge on the basis that it is, quote, unnecessary, i.e., the jury can make up its own mind about general concepts by reference to the guidance which exists in general terms about health and safety. And I just to make that point, some interpret the Turner case as being authority for the proposition that expert evidence must be necessary, which has caused judges to make the ruling this is not an expert case. Now, just going on a little bit, we can skip through these. The major case in relation to expert evidence, and in fact all aspects of expert evidence, is a case called Bonithan, I hope that's how you pronounce it, which unusually is a South Australian case. And in terms of relevant expertise, the court said that the individual has acquired by study or experience sufficient knowledge of the subject to render his or her opinion of value. Impartiality, the expert must be able to provide impartial, objective evidence on the matters within his or her field of experience. And I quote the civil case of Field and Leeds City Council there, which said that for an expert to be qualified to give evidence as an expert, he or she must be able to provide an objective, unbiased opinion on the matters to which his or her evidence relates. And just a rider to that, there is authority for the proposition, which is commonly cited by the HSE, that there's nothing which is improper in a specialist inspector employed by the HSE giving evidence on behalf of the HSE, that in itself does not create some bar towards his evidence being admitted on the basis of a lack of impartiality. And the fourth criterion is evidential reliability. Now this is one which is not necessarily apposite to what I'm talking about today, but just to note it, the criterion is mainly concerned with weeding out cod or dubious science. And I slightly facetiously give a couple of examples: nose prints or astrology. The point being that there may be a body of evidence which suggests that this is something which may be relied upon, but does it have the stamp of being reliable in terms of the generality of opinion? The expert's opinion evidence must, in other respects, satisfy a threshold of evidential reliability. The field of expertise must at least be sufficiently well established to pass the ordinary tests of relevance and reliability. And in Bonithon, the requirement was described as being whether the subject matter of the opinion forms part of a body of knowledge or experience which is sufficiently organised or recognised to be accepted as a reliable body of knowledge or experience. And just to put a gloss on that, the Bonithon test was confirmed in a number of Court of Appeal cases, at least for evidence of an expert scientific nature. Now, one of the issues here, of course, is in effect health and safety a science? Is this something which passes the criterion 4 of that test? Is this something which is understood to be something which is capable of scientific and empirical evaluation? And my general conclusion is, which I'll express at the end, is that effectively it is that this is something which has developed in a very particular way over a number of years. There are a number of qualifications that one can achieve in health and safety management. There are a number of very strict empirical rules which one is expected to follow when addressing health and safety management. And so therefore, in terms of its evidentiary reliability, that arguably it is something which qualifies on that criterion. Now, a couple of other matters in relation to that criterion 4 is that the Law Commission actually proposed a new statutory admissibility test, which is set out in the Criminal Evidence Experts Bill. And I'm not going to go through that. You have that written down. But it effectively covers some of the points which they say guarantee that expert evidence is of a sufficient quality to be admitted. And for what it's worth, the impetus for reform stems from a number of cases in which perceived to be unreliable expert evidence had been admitted and upon which convictions were based. And Gallagher was the infamous ear print case, where somebody was convicted on the basis of an ear print. It was put forward as uncontrovertible science, and then at some point later it was discovered, or it was thought, that in fact it was not as convincing as it was put forward. And Clark and Harris are cases which relate to shaken baby syndrome and cases connected with child fatalities, but we're still awaiting a government response in relation to the Law Commission report. I've said that the test for admission is a common law test, and substantially it is. There are, however, certain procedural limitations in relation to experts, which are contained in, amongst other places, the criminal procedure rules, and I've set those out there, and I'm not going to go through those because you can see them and consider them. Now, this is just a short passage in relation to how the 4 tests fit together. As I said earlier, the main test, the Turner test, ensures expert evidence is only admitted when it has sufficient probative value, i.e. it's likely to help the court to resolve a disputed issue. Numbers 2 and 3 ensure expert opinion is only admitted in criminal proceedings when it reaches a minimum level of reliability. And 4 acts in the same way as 2 and 3, but some different considerations apply. Now, I always tend to look to how the Court of Appeal is going to approach this matter. Is there any justification for calling a generalist to give evidence about, as it were, broad health and safety matters in a field in which he has no specific expertise, but where the prosecution is making a criticism about the defendant's failure to have dealt with health and safety properly in general terms? And the best I can find is in the case of Porter, which I'm sure most of you will be aware of. This was the school case where there were the steps in the playground, and a child playing in the playground fell down the steps, went to hospital, having suffered an injury, went to hospital, eventually, as I believe, contracted some kind of hospital-borne disease, MRSA or otherwise, and died. This went to the Court of Appeal, and Moses, Lord Justice Moses, who's dealt with a loss of the health and safety case, has said this, is that the appellant did not rely upon his own evidence and that of other colleagues. He also called, I think it should be did not rely only upon his own evidence and that of other colleagues. He also called an expert witness. That witness, Mr. Barnard, who I'm sure many of you know, a previous inspector and expert in health and safety, had no particular experience in the conduct of young children in the school playground, but he was hardly to be criticised for that since the prosecution called no expert evidence at all. It must be assumed that they could not find anyone of sufficient cogency to justify being called on behalf of the prosecution, or even to rebut the evidence given by Mr. Barnard. That expert evidence took the view that insignificant risks could be ignored, such as those arising from the routine activities associated with life in general. He pointed out the many risks to which young children are exposed at home and stressed what he regarded as the important feature, that nothing had been identified in the construction or placement of the steps which showed that they themselves constituted a risk of injury. In his 30 years of involvement in health and safety, he had never found any scrutiny under the 1974 Act focus on such a flight of well-constructed external steps. He took the view that steps did not create a foreseeable risk or possibility of danger, still less an unacceptable risk. Had he been the inspector, he would not have taken any enforcement action or remedial measures, would have had no concern about those steps. So, for myself, I've always found that quite an interesting passage, because if you think about it, Martin Barnard there was giving evidence not about anything which was related to a specific industry, not about the application of general guidance, but giving evidence in the most general, and some would say abstract way, about concerns in relation to health and safety, which one might describe as societal concerns, foreseeability, tolerability of risk, and matters of that sort. And whereas Lord Justice Moses stopped short of saying, and in my view, this is evidence which the defence is entitled to call in any case, the fact that he did not, and he's certainly not shy of expressing his opinion in certain cases, the fact that he did not necessarily censure it as being inappropriate to give, certainly so far as I'm concerned, if the argument does arise, may be a basis for saying that that type of expert evidence is admissible. Sorry, I've gone backwards. Now, just going forward. Now, the nub of this argument, I think, is probably contained here, and it's really, as I say, the first objection, the Turner objection. Does a jury need to hear an expert? Should a jury be entitled to hear from an expert in relation to the general matters of health and safety? And what I've said is that an argument is raised against the generalist, that the jury should be able to make up its own mind by consideration of the relevant guidance and the law. And of course, the judge will give the law, and the jury may be referred to the guidance. question is this fair? Health and safety guidance tends to be high level and goal setting. By its very nature, you can't have guidance that, you certainly do have guidance which covers specific industries, but some of the guidance that you get, for example, in the guidance of the management regs and other HSC documents, HSG 48 and 55, is of general application. And if you read through it, it's very dense. It's very dense, and it is often very nuanced. And I have to say, from my own point of view, having prosecuted a number of cases, and I'm sure against some people in this room, I have often found myself literally reading out tracts of guidance to a jury simply as being the material upon which they will make their decision, and then making my own comments as counsel about how that applies to a particular case in a closing speech. So the question is it fair or appropriate to expect a jury to digest and apply unfamiliar guidance to complicated facts? And my conclusion, for what it is worth, is that it's not. And that in a sense it's unfair to the defendant to expect that a jury should be allowed to, or should be required, for example, to take a general HSE document which covers principles which have been refined over years and years of experience, and which develop from civil cases, and which develop from experience within the industry, and as I say, tend to be dense, high level, and highly nuanced, and apply that type of guidance to a particular set of circumstances. And can I give you what I think is probably the best example I could come up with, which is again the issue in relation to control. We all know that under Section 3 of the Health and Safety at Work Act, a person who conducts an undertaking is expected to exercise control over any person who does work on his behalf. And we all know that there is the exception, which was expressed by Lord Hoffman, which says that reasonable practicability may limit the extent of the control which a specialist, that one contractor may exercise over a specialist. And of course that is right, and that is the law. But the problem is that there really is very little guidance on what that control should be. How do you control a specialist subcontractor? What are you expected to do? Are you expected to, for example, check every single ticket of every single person who works on behalf of the subcontractor? And commonly, in my experience, a good health and safety expert commissioned by the defence may say, for example, the control test is of wide and general application. In my experience of industry, in my experience of health and safety matters, the level of control which the principal contractor, or the contractor, for example, applied to the subcontractor was sufficient and amounted to doing all that was reasonably practicable. The alternative is that you simply make an appeal to the jury, and you simply say, well, members of the jury, what do you think? Do you think they did enough? Do you think they did enough to control? Given that control is not an absolute test, do you feel they did enough, or did they not do enough? And certainly my view is that an expert who is seasoned and well versed in the field, who's had experience in working in this type of area for a long time, should be entitled to give his opinion about whether the control that he saw was sufficient or not. Of course, the point is the jury is entitled to accept or reject the expert's opinion. So a couple of other matters in relation to the ultimate issue. And it is still, I have to say, astonishingly still sometimes said in court that the reason that an expert should not be allowed to be called by the defence when the expert is giving an opinion on, for example, did the defendant do all that was reasonably practicable, is because it offends against the rule that experts should not opine on the ultimate issue. Well, I don't think it really needs to be set out, but the point is that that rule, if ever it existed, has been substantially abrogated, and it's commonplace for experts to give their opinion on the ultimate issue in health and safety cases and other cases up and down the land on a regular basis. So we come to the issue of evidential reliability, And as we all know, and as one sees, you will see a blizzard of qualifications that a health and safety expert might possess. There's professional training as well established. You have IOSH, you have NEBOSH, any number of professional qualifications exist, and it's expected by the HSE, and one will often see it in a given case, that those, for example, who conduct risk assessments will be expected to have had professional training in that field. We all know that HSE inspectors routinely look for evidence of health and safety training in those who have responsibility for health and safety management. And that those who are responsible for health and safety management are required to have formal training, and they are, in effect, by virtue of that formal training, no longer laymen. So the question arises, in terms of the assistance point, should a jury, which one assumes and one takes to be a jury of laymen, be expected or required to judge whether professionals in their field, and who are expected to be professionals in their field, have acted in accordance with the prevailing standards in the field. And my conclusion is that a jury should be assisted by expert evidence. Now, I said it wasn't much about environment case, and bound to say it's not, but there is one case which was recently heard in Exeter, which was an interesting case in relation to the extent of expert evidence. And this was a case which concerned a particular thing, a particular product or material, in this case a bale of tyres, and there were numerous bales of tyres. And the issue in that case was whether this was waste in accordance with the EPA, Environmental Protection Act. And in fact, so far as the case was concerned, this really was the ultimate issue, because the job of the prosecution in that case was to prove, as a matter of law, that the thing in question was waste. And in that case, the defence called an expert called Professor Willits, who gave evidence about whether, in his expert opinion, this bale of tyres, these bales of tyres, were waste. And in doing so, he cited all manner of documents, including European directives and guidance notes. And that was considered to be an acceptable basis for an expert to express his opinion. So, if you can't have an expert in health and safety law, what can you have an expert in? Well, I've listed some of them there. I'm not going to go through the whole list. You can see many of the ones which one sees at the top of the list are well known and uncontroversial. But for example, if you go towards the end of the list, you see an expert in historical facts. You see expert literary critics, experts who may give evidence about whether a piece of literature has any kind of merit. And of course, one has, on a regular basis, forensic accountants. And from my own experience, I've certainly called one expert who came over from America, and his expertise is why policemen kill, perceptual issues in relation to why policemen shoot innocent people in unusual or unexpected circumstances. So the reality is that there is, if one looks at it and one cares to go through all of the cases, there is a bewildering range of expertise which has been admitted and cited as being acceptable in court. And I think simply upon that basis, one is entitled to ask the question, well, if these are entitled to give evidence, then surely it is permissible for a health and safety expert to give evidence about general matters of health and safety in a health and safety case. So that's my conclusion. The conclusion is that there is no principal reason, and I think that's the point, there's no principal reason why the defence should not be able to call an expert in a health and safety case. There's no principled reason why the defence should not be able to call. And of course, the expert has to be suitably qualified. To get somebody who simply has an IOSH qualification and nothing else, that there's no principled reason why an expert should not be called by the defence to give the jury assistance with the key questions, the nub of the issue. Did the defendant do all that was reasonably practicable? Did the defendant exercise sufficient control, for example, over a subcontractor, or indeed did the defendant exercise sufficient control over employees in given circumstances? So, as I said at the beginning, there is no massive topicality in my giving the address at the moment. There's nothing, as it were, coming out. But my own sense is that given the health and safety cases have been proliferating in the courts for a number of years, and the prosecution routinely call experts, and we who are defending cases often seek to call experts, in my view, and with some, I think, some justification and experience, there is going to come a point where a judge is going to say, well, hang on a second, why do you say this expert evidence is admissible? Why do you say that a generalist, for example, such as Mr. Barnard in the Porter case, should be able to lecture us on issues of a general nature concerning risk and health and safety, and even, of course, foreseeability and matters of that sort? And given that there is a trend towards knuckling down on criminal cases or cases which occur in the criminal courts, my expectation is that we will reach a pinch point. We will reach a point where there is going to be some fairly intense judicial scrutiny of this type of area. And I hope to look at it in this way, to separate it down into the four elements, especially the first element, to make the point that health and safety is now is not just something which is vague and casual. It's something which is expected to be dealt with in a scientific or quasi-scientific way, that there is, in general terms, a basis for saying that you can call an expert to say that the general principles of health and safety law have been dealt with in a particular case. So that's it. Thank you very much.